Good afternoon, dear colleagues and guests who may watch our session of the Dissertation Council online at St. Petersburg University website. Let me declare open a session of the Dissertation Council. And the subject of today's session is the defense of thesis by Olga Anatolyevna Kiseleva for the degree of Candidate of Legal Sciences, Academic Specialization 120010, International Law, European Law, on the theme, Application of the Norms of International Treaties in the Practice of Commercial Courts of the Russian Federation. Under order of St. Petersburg University of the 13th of April 2020, me, Timoshina Elena Vladimir, Doctor of Legal Sciences, Professor of the Department of Theory and History of State and Law, St. Petersburg University, was appointed chairman of this dissertation council, and other council members were appointed with the same order, and I'm pleased to introduce them now. And before introducing my fellow council members, let me inform you that under the St. Petersburg University order of the 23rd of March 2020, our meeting is being held in the remote interactive mode, which includes my colleagues, members of the council, whom I would like to introduce now. Ludmila Petrovna Anufrieva, Doctor of Legal Sciences, Professor of the Department of International Law at the Moscow State University of Law, named after Kutapin. Ludmila Petrovna, can you hear us? Yes, I can see and hear you. Thank you. Thank you, Ludmila Petrovna. Vyacheslav Vyacheslavich Gavrilov, Doctor of Legal Sciences, Associate Professor, Head of the Department of International Public and Private Law of Far Eastern Federal University. Vyacheslav Vyacheslavich, can you see and hear us? Yes, good afternoon, colleagues. Everything is perfect. Thank you. Sergei Yurievich Marashkin, Doctor of Legal Sciences, Professor, Department of International Law, Tyumen State University. Sergei Yurievich, can you hear us? Yes, good afternoon, everybody. Yes, I can see and hear you. Thank you. And Professor August Reinisch, Professor of Vienna University, Austria. Dear Professor Reinisch, can you hear us? Please say yes, if you can. Professor Reinisch, please say yes, if you can hear us. Professor Reinisch, can you hear us?
I have heard my name, but not any translation. So
could you please say yes? Could you please confirm that you can hear? Can you please confirm that?
Уважаемые коллеги, мы вынуждены сделать технический перерыв на 5 минут. Спасибо.
Then let us continue. Let us continue. Dear colleagues, let's resume online broadcasting. And let me once again ask Professor August Reinisch of University of Vienna, Austria. Professor Reinisch, can you see and can you hear us? Please say yes.
Yes.
And of course, the degree applicant is present. Olga Anatolyevna Kiseleva, can you see? Can you hear us? Yes. Dear Chairman, dear members of the Decision Council, I can see and hear you. Thank you. Also, there's the academic advisor of the degree applicant, Vitaly Simonovich Ivanenko, Doctor of Legal Sciences, Associate Professor of the Department of International Law, St. Petersburg University, Vitaly Semyonovich. Can you see? Can you hear us? Yes, I can see and hear you, and I'm glad to take part. So all the members of the Decision Council, as well as the degree applicant, are present, and we can all see and hear each other. And since under the order, the 23rd of March 2020, our meeting is being held in the remote access mode, I invite all the participants and all the members of the Decision Council to follow the procedure. And in case there's a technical failure and you stop seeing or hearing someone, please inform me immediately. In that situation, I should call a technical break until such issues are eliminated. And if the connection with me is lost, I would like to ask Ludmila Petrovna Anufrieva, the council member whose name comes next on the list, to call a technical break. And until connection with me is re-established. Ludmila Petrovna, do you agree? Yes, I agree, except that in that case, I need to decide for how long shall the technical break be. And I'm not sure how can I decide. Let's call a technical break until technical issues are eliminated, hoping that elimination of such issues shall take no more than 5 minutes. And dear council members, do you mind this arrangement? Do you have any objections to this arrangement? That if the connection with me is lost, Ludmila Petrovna shall call a technical break. We agree. Yes, we agree. Professor Reinisch, do you mind? Do you agree?
Yes, I also agree.
Yeah. Dear colleagues, please to improve the sound quality, keep your microphones switched off, but please remember to switch them on when you're given the floor. Also, let me inform you that our meeting is being recorded and broadcast online at St. Petersburg University website. And the speeches are being simultaneously translated from Russian to English or from English into Russian. The applicant's page currently displays an email to which, during our session, all the attendees of the Dissertation Council session may send their opinions and questions to the degree applicant online, questions related to the thesis and the ongoing scientific discussion of her presentation. Our technical support department shall forward the questions to me, and by the decision of the Dissertation Council, they shall be presented. Let me especially emphasize that questions should be related to the presentation of the degree applicant, contents of her thesis, and include full name, position, place of work of the author of the question. Questions that are not related to the scientific discussion, to the discussion of the thesis or evaluation of the thesis shall not be presented. And in accordance with the order of awarding at St. Petersburg University, the degree of Candidate of Science or Doctor of Science, a session of the Decision Council is considered competent if at least 2/3 of the approved composition of the Council takes part in its work, but not less than 4 persons. Our Dissertation Council consists of 5 members. 5 members are present, all in the remote interactive mode, and audio-visual contact has been established to all of them, and thus we have the quorum. And let me also instruct the curator, Ekaterina Vyacheslawovna Sazonova, officer of the Dissertation Council Activity Support Department, to draw up the attendance list in which the Dissertation Council members present shall be recorded, and to indicate their work mode, in this case remote. Our session has a procedure, and the approximate duration of our session shall be, let me emphasize, approximate shall be 2 hours. And dear colleagues, dear members of the Dissertation Council, since the procedure is, you are familiar with the procedure, we sent it to you. I ask your permission not to read the 14 points, but proceed straight to presentation of the documents. Dear council members, are you okay with this? Ludmila Petrovna, what did you say? Ludmila Petrovna, please switch the microphone on. No objections. Thank you, Professor Reinisch. You're okay with this. And thus, since there are no objections, let me start running the procedure. And would like to give the floor to the academic advisor of Olga Anatolyevna Kiseleva, Simonovich Ivanenko, Vitaly Simonovich. Let me draw your attention that you will be given the floor on the content of the thesis in the end of our session, after reviews by the council members are presented, and after Olga Anatolyevna answers questions and comments. So now I'll give the floor, you're given the floor for a brief introduction, please. Thank you, Olga Vladimirovna, dear chairman, dear council members. As an academic advisor, very briefly, let me introduce the degree applicant, Kiseleva Olga Anatolyevna. Kiseleva Olga Anatolyevna, in year 2008, graduated School of Law of Tomsk State University, judicial legal system. So I beg your pardon. This information is available at the attestation file of the degree applicant. In parallel with her professional activity, she became a doctoral student at the Department of International Law, and it took her more time to write her thesis 2 years ago. 2015, she's been teaching at Omsk, is married, has 2 sons, and and today she would like to present her thesis to your attention. Thank you, Vitaly Semyonovich. And here I have to introduce briefly, give a summary on documents on the basis of which the thesis was accepted for defense. The thesis was accepted by the order of the Academic Secretary of St. Petersburg University on the 10th of April, 2020. And as already mentioned by Vitaly Semyonovich, Olga Anatolyevna wrote her thesis at St. Petersburg University, a number of publications which set out the main scientific results of her thesis. According to the submitted list is 9, and 6 publications in peer-reviewed scientific journals from the list approved by the Ministry of Education and Science of the Russian Federation, and no publications in any other journals included in the Web of Science and Scientific databases. The applicant submitted to the Academic Secretary of St. Petersburg University a full package of documents for acceptance of the thesis. For consideration and defense, all the documents comply with Article 12, comply with the applicable requirements. And all the documents are available from the curator of today's defense officer, the Education Support Department, Ekaterina Vyacheslavna Sazonova, who's currently in touch with us. And before I give the floor to the degree applicant, I have to ask dissertation council members, do you have any questions to the applicant? And is it necessary to disclose and discuss the entire list of documents submitted by the degree applicant? Ludmila Petrovna, do you have questions? No, I have no questions. Thank you. Vyacheslav, do you have questions? No, I don't. Thank you. Sergey Yurevich, do you have questions? No, I don't have questions. Thank you. Professor Reinisch, do you have questions regarding documents?
No questions at this stage.
Thank you. So I'd like to give the floor to Olga Anatolyevna. You're given the floor for your presentation that should outline the key points of your research. And according to our procedure, your presentation should not exceed 15 minutes, please. You have the floor. Thank you very much. Dear Chairman and Dissertation Council members, let me present to you my thesis on the theme application of the norms of international treaties in the practice of commercial courts of Russian Federation. Relevance and scientific novelty of the topic is due to the fact that despite the quarter-century implementation of the provisions of Part 4, Article 15 of the Constitution on the entry of the international treaties of Russia into the Russian legal system and the possibility of their application, arbitration court practice has not yet developed common approaches to such application. Scientific novelty of which condition is been working in the judicial system for over 12 years. Over 10 years I've worked in the arbitration court, working an assistant. And in my practical opinion, I faced many issues that complicate efficiency of the courts. When choosing my topic, I paid attention to 2 circumstances. Firstly, in practice, application of international treaty rules by courts of arbitration jurisdiction is facing serious problems. It became clear that for judges, the process of applying the laws of Russian law is much closer, familiar, and understandable than a similar process with regard to international laws and treaties. Secondly, in modern Russian science, when research and application of international law in judicial practice, the general trend is to focus on the activities of the ordinary courts and the constitutional court. On the other hand, activities of arbitration courts are even not studied at all, or they receive unreasonably little attention. In recent years, while maintaining its relative isolation and continuing to have a certain own identity, even after the judicial reform of 2014, the arbitration justice has been in need of specific scientific and theoretical developments, including on the application of international treaty norms. Thus, it became clear that scientific and practical elaboration of these issues and the introduction of its results into everyday practice of arbitration justice would contribute to the efficiency of arbitration proceedings and strengthen the authority of the judiciary. By choosing this topic for my study, I sought to focus on those aspects of the application of international treaty norms that distinguish the arbitration justice from other types of justice. At the same time, admitting that there are not so many peculiarities and nuances that cardinally affect the process of application of international treaty norms in arbitration courts. Though there are some. It was therefore clear that without special and in-depth research in this field, it was completely unjustified to mechanically extend the theoretical developments in the field of general jurisdiction courts. While working on my thesis, I highlighted a number of basic aspects of status, operation, application of international treaties in the Russian legal system, which remain controversial and to which I paid special attention. First of all, this concerns the very status of international treaties in the Russian legal system. Traditionally, in the domestic literature, the international treaties are analyzed as agreements between contracting parties, indicating their conciliation nature. The question of their regulatory status in the hierarchical system of Russian law has hardly ever been raised. But in recent years, this issue became very controversial, especially in connection with the trial of Ushakov in the Constitutional Court of the Russian Federation. One of the main questions before the Constitutional Court in this case was whether or not an international treaty was a legal instrument, whether or not it fell under the scope of Article 3 article of the Constitution, which states that only published legal acts may be applied in the Russian Federation if they affect human rights and freedoms. In the end, the Constitutional Court gave a positive answer to this question. Nevertheless, the issue continues to be debatable. In forming my position on this point, I, as an employee of the system of arbitration courts, could not but take into account the provisions of the Basic Regulatory Act for our system of justice, the Arbitration Procedure Code of the Russian Federation. Article 13 is entitled Normative Legal Instruments Applicable to Cases. According to paragraph 1 of this article, I'm quoting, arbitration courts shall consider cases on the basis of the Constitution of the Russian Federation, international treaties of the Russian Federation, and then there's a list of other legal acts, such as the federal constitutional laws, etc. The same wording is also present in the Russian Code of Civil Procedure. Thus, the Russian legislator has incorporated the international treaties into the system of legal acts of Russia, and our arbitration courts are guided by this. The recognition by the Constitutional Court of the legal nature of international treaties was of great importance for the arbitration courts because it helped to determine the place of treaties in the hierarchy of applicable regulations. This decision of the Constitutional Court also helped me to choose the main focus of my research as analysis of application of the international treaties as legal acts in arbitration proceedings. It's therefore no coincidence that the problems of determining the status and place of international treaties in the Russia's legal system became the subject of study in Chapter 1 of my thesis. Having determined the status and place of international treaties, we moved to Chapter 2, which is devoted to the analysis of the specific features of conceptual legal grounds for the application of international treaty norms. These grounds are considered in the context of both international and Russian law. The main part of my thesis is Chapter 3. In this chapter, the main problematic issues concerning the status and application of the international treaty rules in arbitration proceedings. Dear members of the Legislation Council, I will not dwell on the contents of these 3 chapters. It will take a long time. You have carefully read my thesis and made a number of serious comments, suggestions, and recommendations on it. At the end of my speech, I'd like to say the following. First, when conducting my study, I approached the formulation and analysis of the issues under study as an employee of the arbitration system, first of all, from the point of view of the needs of the arbitration practice, trying to reflect its painful and problematic aspects, sometimes, unfortunately, in the theoretical aspects of the issues under study. Secondly, I've carried out the first comprehensive study in the legal literature of theoretical and practical issues of applying the rules of international agreements in arbitration proceedings in the Russian Federation by all instances of courts of arbitration jurisdiction on the basis of the new arbitration procedural legislation and its latest amendments. This allowed a number of new and, in my opinion, useful scientific and practical conclusions to be drawn, some of which are given as provisions to be protected. Third, my analysis shows that, after all, the Russian arbitration court system as a whole perceived the international agreements as a really in-demand source of arbitration proceedings, the use of which, as a rule, is in necessary cases really contributes to the improvement of the efficiency of arbitration courts and judicial settlement of economic disputes. However, while studying practice of application of international treaties by arbitration courts, we notice that it is still ambiguous and contradictory, and references are often incorrect, even legally unfounded, or on the contrary, wrongly absent. So far, unfortunately, the necessary uniformity has not been achieved in the general understanding the application of the national norms. Many of the existing problems also result from the terminological vagueness in understanding the nature and status of the Russian international treaties in the Russian legal system. 4. In my work, I took the liberty of justifying the need for a uniform understanding and the interpretation of the law enforcement practice of the concept of a treaty as an international legal instrument by proposing to depart from the perception of the treaty as an agreement between the contracting parties. As a result, the work I concluded that an international treaty should be defined as an international legal instrument adopted by the competent subjects of the international law on a conciliatory basis aimed at regulating public relations of mutual interest to the contracting parties and firmly legal binding on the parties, its bodies, where proper, its legal entities, and when appropriate, its legal entities and individuals. 5. The analysis of the regulatory sources, clarifications from the highest arbitration instances, arbitration court practices, enabled us to make four options for possible application or non-application of the international treaty norms by arbitration court in consideration of specific cases. First, the simple reference to the Russian international treaty in the text of the Judicial Act, in a general list of applicable sources without reference to specific articles and provisions of the treaty. Secondly, direct application of the international treaty of the Russian Federation or its specific articles as a legal regulator of legal relations considered by the court. Thirdly, drawing conclusions that the international treaty is not applicable. And fourth, there's no reference to an international treaty, which should nevertheless apply to a legal relationship. And finally, according to the author, in practice, the model of Russian arbitration courts for the administration of justice using the rules of the international treaties has been formed. What's important in this model for our study is the definition of the nature of norm of an international treaty. It's either additional or exclusive of the Russian law. In case of the additional nature of provisions of a treaty, norms of international Russian law should be applied in the aggregate, enriching and detailing each other. And in case of an exclusionary nature, the norm of the international law should be applied by virtue of its primacy in the sphere of law enforcement, as it follows from Part 4 of Article 15 of the Constitution. Thus, it appears that goals of the thesis have been achieved, problems and possible directions and means of their solution identified, and ways of improving efficiency of the arbitration justice administration using the rules of the international treaties have been formulated. My report is over. Thank you very much for your attention. Thank you, Olga Anatolyevna. And dear colleagues, dear Dissertation Council members, do you have any questions to Olga Anatolyevna or regarding her on her presentation. Ludmila Petrovna, do you have questions? Yes, thank you. Yes, I have a number of questions, and let me start maybe with an easy one. What do you mean by status of an international treaty? This is my first question. I think you should take each question, answer each question. Thank you, Ludmila Petrovna. First of all, the idea of status I included in my understanding of the international treaty and first paragraph 1 of chapter 1. I did not hear you. What do you mean? What is the content of this term when you use it? When you apply it to an international legal act? In your work, you use the word status, but you don't use the word place, position. Yes, Ludmila Petrovna, in my work, I first of all explored the status of an international treaty as an international legal act, and further in my work, I tried to explore the position of an international legal in the Russian legal status. And as I understand, Ludmila Petrovna is trying to say that status is usually applied to subjects of law rather than a treaty. Is that correct? Yes, I tried to explain my idea in my additional question, but an answer has been given. And one more, if you let me ask. Elena Vladimirovna, may I ask one more question? Please tell us, you focused your attention in your report and in your thesis that you are dealing with application of international treaties in arbitration practice. As someone working in this system, so I'd like to know what are the theoretical issues can you see in the activity of the arbitration courts in the sphere of application of international treaties today. So what exceptional or what specific issues or challenges are the arbitration courts facing when dealing with application of or non-application of the international treaties? Thank you. Thank you, Ludmila Petrovna, for this question. Well, maybe the main challenge, in my opinion, is or maybe of a theoretical nature, and it's an internal challenge. So we identified within the system that many judges they treat international treaties as something foreign, and if they can, they try to minimize the need to refer to it, and so application is always a problem. So the problems start from there, because obviously all the judges are professionals, and so this application should happen on a high level, and not have information how an international treaty is included in the national legal system. So what is its position? What characteristics of an international treaty should be studied in order to conclude that the international treaty should regulate these issues, and further, what characteristics are necessary for the court to be able to apply it. And one of the key characteristics for this is being officially published. So that's it in a nutshell. Thank you, Olga Anatolyevna. Do we have more questions? I have a small comment, if that is okay, and then one more question. And my comment is, Olga Anatolyevna, I think you can feel yourself that now you're talking not about the theoretical, you are speaking about pragmatical or practical, maybe psychological issues, cognitive, but not about the theoretical problems. So you have not mentioned, unfortunately, any theoretical problems. And then I have another question, a very practical question. Please tell us, are you familiar, for example, with cases of the past 5 years in which it became very obvious, this drawback of absence of theory and the need for the judges to improve their qualification, to apply justice and use the latest theory. So here's what I mean. During the past 5 years, or maybe since 2014 to 2017, arbitration courts proved that, or they tried to prove as great innovators in the sphere of addressing issues, complex issues of relation of treaties, between treaties, especially in the part of their application in arbitration practices, Bryansk customs, Tver Tamoshna and Baltic customs cases became widely known, and the famous ruling of the Supreme Court in this sphere appeared. In other words, this is one point, and the second point is on a well-known decision of Arbitration Court of St. Petersburg and Leningrad Oblast, taken in 2015, and in these cases, do you feel any theoretical issues? If you do, please let us know. If Lyudmila Petrovna, thank you for this question. This is a very interesting question, and let me tell you that certainly I could have missed some issues. If we talk about your first example, the relations between international treaties and the theoretical issue connected with the customs regulations, unfortunately, I have not studied them in detail, but as for the second case of 2015, indeed, there was a theoretical issue which is connected with immunity of the state in the arbitration proceedings, and I wanted to talk about that when answering one of the comments in the reviews, but maybe I should I answer this, should I talk about it now or later when answering other questions? Let me ask Elena Vladimirovna. I cannot hear you. Since our regulation requires that you give short answers. Let me ask you, keep this question in mind and get back to it when answering other questions, because our procedure requires that you give short answers. Lyudmila Petrovna, I did not mean fabula the case, and it's a, I wanted you to name only the challenge, not immunity of the state. Of course, immunity of the state, but there are many other theoretical problems. First of all, validity of the agreement, its application, timeliness of its application, and other issues related with the treaty being effective in the legal system of a given state, Russian Federation or any other state. But you have not mentioned any theoretical problems. But the story of the case you can give later. But to my question, you have not given a good answer. Olga Anatolyevna, can you add something briefly? Briefly, thank you, Lyudmila Petrovna. I did not want to give the fabula of the case. In this case, what was important for me is that the commercial court, the arbitration court, could interpretation offered by European Human Rights Court or immunity of the state apply while it didn't have legal framework in the Russian judicial system, only because an applicable law was only taken in November. So for me, it was interesting in my study. For me, that was interesting. Thank you, Olga Anatolyevna. Lyudmila Petrovna, do you have more questions? Thank you. Of course, I don't want to take up the time of my colleagues. Thank you. Vyacheslav, do you have questions? If any. Yes, I have a very short question on the basis of what Lyudmila Petrovna said. And I think that in this dissertation council, we will mostly have theoretical questions because so my question is, your logic is strange. An international treaty should be considered a legal act because that's what the Russian legislation says. Don't you think that it should go exactly the opposite way? Russian legislator should make provisions on the basis of proper understanding of the international legal acts. So can this be an international treaty become a basis for validation of thank you, Vyacheslav Vyacheslavic. Olga Anatolyevna, please. Thank you, Vyacheslav Vyacheslavic, for this question. Of course, I agree. If I only referred to the arbitration code, you would be right. But let me inform you that in my presentation, I drew your attention to the fact that there are decisions of the Constitutional Court regarding this issue, and the Constitutional Court gave its reasoning and confirmed that the international treaties should be regarded as international legal acts. And in my thesis contains other evidence and explanations. Of course, it's possible to discuss this evidence, and I specially given this to prove its practical significance, but it's important that it reflects the current situation. Thank you, Olga Anatolyevna. Vyacheslav, do you have more questions? I would like to draw the attention of the author, of the degree applicant. I remember your reasoning, and we shall get back to it, but I'd like to draw your attention to theoretical, is incorrect to explain the theoretical provision on the basis of incorrect practices. So I would like you to use this method only when it's you have all reasons. Thank you. I don't have any further questions. Sergey Yurevich, do you have questions? The presentation of the author is so all the same question. I have the same questions that I've included in my review, so I don't have any. I haven't got any new questions. Thank you, Professor Reinisch. Have you got any questions regarding the presentation of the degree applicant?
Okay. If I understand you correctly, there will be a second round in regard to questions that have already arisen. So I should restrict myself here just to the presentation. Is that correct? Yeah. Okay. No, in regard to the presentation.
Yes, that's correct.
Yeah. In regard to the presentation, I don't have any further questions. So I will reserve for the next round. Thank you.
Thank you. But before I give the floor to the members of the Dissertation Council, we have to decide how what order shall we follow and how the degree applicant shall answer comments and questions asked by the Dissertation Council members. And here we have two options. Either Olga Anatolyevna answers each reviewer individually, or she takes all the questions and comments in the end after all the Dissertation Council members. I suggest option 2. I suggest the second option. And after all the Dissertation Council members present their reviews, Olga Anatolyevna shall answer all our questions. I have one question. If in written review there's the number of questions asked is different from the number of questions in the review, shall the degree applicant answer only questions actually asked by the council members? And a comment. I would agree with your opinion to sum it up, but my experience is that degree applicants forget many questions and comments asked and never answer them. So I'm all for summing up repetitive questions and comments, but at the same time, I don't want any questions to be omitted. So if the degree applicant promises to answer all the questions and not to forget anything, then I don't mind this procedure. As for questions asked by the Dissertation Council members included in the written reviews, I think the degree applicant should be prepared to answer both types of questions she already knows and new and questions asked. Olga Anatolyevna, do you promise to remember all our questions? I see that many of ours included the same comments. You can promise? Yes, I will do my best. Dear Dissertation Council members, let us stay alert, and it's hard for the degree applicant to take all these questions at the same time. I am for second option. I prefer the second option because some questions will be the same. Why should we hear the same questions repeated? Let us be rational. Professor Reinisch, what do you think? How should the degree applicant answer questions?
Yeah, I do not have any very strong feelings about it. And I agree with the point that there's no need to repeat them. But since I've just heard my colleagues concern whether all questions will be answered, it might in fact be easier if we have different rounds of questions, answers, and if any of us feels that one of the questions has not been sufficiently answered, we can immediately go back. And to take into account the concern of repeated questions, I would be very happy to concede that one of my questions has already been answered and don't have to pose it again. But so that probably would rather be in favor of the first variation.
Vyacheslav, thank you, Professor Reinisch, for your opinion. Vyacheslav, we did not hear you. Could you please say again? Yes.
Okay.
I said that we have different opinions, and let's do it as follows. I think many questions will be similar, so I suggest if a previous reviewer has asked a question, I suggest that the next reviewer should omit this question to save time. So I suggest we can trust the degree applicant to group all the questions, but with one condition. If any gets any doubt, let the chairman, after the degree applicant answers all the questions in the end, ask each council member if there are any unanswered questions and if the council members are satisfied. If that is accepted, I think we can, yes, such clarification certainly shall be asked by the chairman. It's in our procedure, first of all. And secondly, yes, I think that each of us should stay alert and watch if the applicant has answered his or her question. Since we have already spent a lot of time on this discussion, thus we may decide that Olga Anatolyevna will answer questions after all members of the Dissertation Council speak. Is that okay with everybody? No objections? No, we accept it. We accept this decision. Professor Reinisch, you okay with that?
As I said, no strong feelings. I'm fine with that.
Thank you. And before I give the floor to the Dissertation Council members, I have to read two external reviews to Olga Anatolyevna's thesis. The first review was submitted by Olga Nikolaevna Tolochko, Doctor of Legal Sciences, Professor of the Department of State Administration of Belarusian State University. Since all the reviews were published at degree applicants page, I shall not read the entire review, just focus on the key points. The review is positive, and Olga Nikolaevna mentions in her review relevance of the theme, good logical structure, and the correspondence to goals and tasks. Then there's a brief characteristics of the contents of the thesis, and especially says that chapter 3 accumulates a vast amount of practical information, empirical data, the use of international treaties, and Olga Nikolaevna believes that on the basis of this, the author makes a scientific solution and offers conclusions, and authors solutions to questions, practical questions. The author, according to Olga Nikolaevna, has analyzed reasons for contradictions in application of international treaties, and further mentions that the author suggests ways to improve the effectiveness of judicial method applying the norms of international treaties. At that, perhaps the rules and regulations should be more clearly formulated in the format that arbitration courts could use. The reviewer emphasizes that seeing an international treaty as a legal act deserves attention, but at the same time, we'd like to hear justification for the need of such a concept. And then the author mentions the list of sources and number of scientific papers published by the author. Says the author contains many discussion points, mentions one regarding international treaty and defining it as a legal act, and nothing affects the overall positive opinion, which is logical, clear, high level of theoretical significance, and the experienced author can be used in practice, and the author also mentions high practical significance of the study, and concludes that the work corresponds to the applicable requirements, and the degree applicant deserves to be awarded the degree of Candidate of Legal Sciences. The second review was sent by the judge of the arbitration court of Hanti-Mansi region, Candidate of Legal Sciences, Vera Andreevna Bether, and the review is also positive. The author, in her review, Vera Andreevna mentions that the author covered in many complex issues, offered her vision of answers to such questions, and Israel practicing judges experienced difficulties in application of justice, the law of international treaties, and the ratio of international and the national law. Further, the author discusses the structure of the thesis. The author, Vera Andreevna, mentions that the study enabled the author to comprehensively study and generalize all the most significant aspects of the topic of the thesis. The author also pays attention to the definition of the international treaty as a legal act, and this says this needs better justification during the presentation. She believes the the approach of the author is interesting, and believes that the second chapter is interesting for practicing lawyers because of its practical significance, and when characterizing the first chapter, says it concludes ideas of the author given in chapters 1 and 2. And this completes the originated thesis and also relevance on enforcement, but in light of what's proposed study of scientific approaches. And then the thesis is based on the analysis of the national, international legal material, law enforcement acts, and a deep study of various approaches. Validity and reliability of scientific provisions in the thesis submitted for defense correspond to the goals and the objectives of the study, and the author also mentions some contradiction applying norms of international treaties. It's contradictory and inconsistent, and believes that because of that, the author suggests logically clear structure, logical structure. Probably she means the structure of the position of the international treaty in the system of law applied by judges, and further says the author's done other noteworthy proposals that could increase efficiency of Russia in fulfilling its obligation. And to sum it up, summarizing the above, Vera Andreevna concludes that this the study is relevant, dedicated to issues that have not been previously studied, and suggests that the author should provide practical recommendations for courts that could be based on the results of her study, and also says that Vera says that novelty is an independent study, corresponds to and all these logical, well justified, make a significant contribution, and has necessary elements of scientific novelty. And despite some critical comments, the author believes that the thesis corresponds to the requirements, and the author deserves to be awarded the degree of Candidate of Legal Sciences. So these are two external reviews, which also contain some comments on the definition of an international treaty as a international legal act. And so this same comment was made by most dissertation council members. Hopefully Olga Anatolyevna will not omit this. So let us proceed to speeches. Give the floor to the dissertation council members. Let me give the floor to Ludmila Petrovna Nufrieva. Ludmila Petrovna, the floor is yours. Thank you. Dear colleagues, I think by no means we shall read full texts of our reviews, which have been published, especially considering the time limit. So let us focus on the key points, which are on the one hand advantages and big drawbacks or shortcomings in the approaches, the interpretations, etc. And for this purpose, I would like very briefly to say that it's impossible to question relevance of this theme. This theme will, in my opinion, will remain relevant for a long time in the limelight of our attention, and I mean theoretical and practical attention. So it's quite important that the author they decided to explore this, but I cannot but mention that this thesis this is not common to a legal act. This is should be a theoretical work which take further the science, legal in the international legal science, and here we come across the most serious issues regarding evaluation of this thesis. The main problem of the main theoretical problem is that the author suggests this is only an initiative was already given by other authors and the academic advisor Vitaly Ivanenko, and following this hypothesis that an international treaty should be interpreted as a legal act, normative legal act. I saw reviews of my colleagues, and I noticed that many, not only me, noticed this point, but so that is why it will be, so I'm sure this proposal has many aspects, and even though it is connected with one scientific idea, but looking at it from different angles, one way or another, and so today it will not be possible to give an incomplete answer, and since I was given the floor, so with which I maybe not very happy, because I have comments and general and specific comments, remarks. So maybe I should focus should have focused on specific issues, and the general issue, to leave the general issue to the other members of the Decision Council, and especially if we talk about this relation with theory of state and law, because different methods, it depends on different methods, but anyways, considering this, first of all, what I would like to say, since this is the academic specialization is 120010. First of all, we'd like the applicant to give arguments and to answer question. What do we get? What can be provided with by turning an international treaty and calling it a normative legal act, what do we get in contrast to taking an international treaty as a special form, as which has features imminent to international agreements, traditionally practiced, and which or the drawbacks of which are not really obvious. And as for exactly which theoretical issues arise in connection with this, here we should not forget that an international treaty in hierarchy, or the relation of an international treaty with domestic law, is the issue of how the international treaty is quality. It's quality. It's in the aspects of national law. And another question that I have in relation with this idea and in the attempts to understand, to comprehend this idea, because if its benefits, to understand its benefits, another aspect here should be added is, okay, so maybe perhaps the treaty itself do not have the regulatory power, but maybe this is not the case, and the international agreement without any additional coatings is quite obvious. But well, maybe in my opinion, maybe the author will offer something, will add something, maybe she has some new ideas on this, and as an additional element that will be added to arguments for and against, and answer questions during the and when answering question, and maybe there will be some other aspects to which she will have to pay attention, the author. In the thesis, I noticed there are some exaggerations of some issues which seem to the author correct to the author, which are based on today's practice. First of all, I mean evaluation of development of the national legal system on the basis of Part 4 of Article 15 of the Constitution. And the author says that these provisions provide because this included international treaties in the legal system of Russia. This is not really so, and after some investigation, the author itself would doubt this statement, and I gave some the Russian Constitution is the main the cornerstone of this, Though, of course, there is inclusion of in the Russian legal system, of the Russian Federation of international treaties. And as for another point which caught my attention, I regret, though it is not as significant, I regret to say that the author misses the opportunity she had to demonstrate her position, her opinion. I mean, too much. She has too much trust to some acts of supreme legal bodies. So the order of Constitutional Code of 2015, in which the issue of arbitration and if the author paid more attention to the title of this act, she would have her own arguments she could use to as a starting point for some provisions which maybe were not directly related, but would become a bridge. Then the thesis would be the study, which is called a study, scientific qualification paper. So here it's impossible to avoid theory altogether, in which it's impossible to avoid theory altogether. And the author only touches upon this, and she is given her critical. The author is given her critical remarks, but the theory she omitted. So, what is the theory? Connected with terminology as procedural act. I would like to draw your attention if maybe we missed this for the first time in our national history, Soviet and post-Soviet history. The procedural act was included the term which has never been used before, because it discredits the entire essence of justice when actors are called elements. And here's my greatest concern, which I which I include in my review. This is a serious issue. As for the other, maybe one more serious aspect is that the author, even in her structure, in the structure of her work, she included this as a paragraph and used exactly this terminology, the international legal reasons for domestic or internal reasons, domestic reasons or Russian and international reasons. I think here the author is very wrong. What could be as international legal reason for application in any case to look for answers in the international treaties is useless, because no international treaty will contain this, and will never contain this, because the international law is applied only with the sanction of the national judicial system. And if the author, is it true, and to check this, and we start reviewing treaties, we will get evidence that international treaties do not talk about this. So I gave one example. I refer to one treaty as an example. So International Judicial Cooperation. It would be possible to give dozens of other examples. I only mention one convention, and even the latest conventions, not only of 1960s and 1980s, but also the Convention on International Judicial 2019, the rulings of 2019. In other words, it's possible to check, but trust me, nowhere we will find this reference of the international legal reason. I made such a selection. Unfortunately, I don't have much time. I've used it up to expand on this, but here, not so much my comments, but brief characteristics, as comparing with provisions, can give an answer of what quality these provisions put for defense. So in my review, I could not make a conclusion on that could not answer in my opinion. The act that is active in this dissertation council, but I believe that it might correspond, but the final answer, my final opinion, I will give only based on the results of today's session. Thank you, Ludmila Petrovna. And when voting, members of the dissertation council are not bound by their opinions they have given in their reviews. Thus, a negative review may turn positive, and the positive review may turn opinion may turn negative. What I'm saying is that we are not bound by the opinions we have given. Thank you for this clarification, but I always believe that I cannot act as I have to be guided by my own opinion, and so I will make my decision after I get satisfactory answers. Thank you, Ludmila Petrovna. And I would like to give the floor to the member of the dissertations, Vyacheslav Vячеславович Gavrilov. Please turn the microphone on. Thank you for giving me the floor. I will try to be brief. I think the tone of today's session is very practical and businesslike. I think that there are three basic points. First is, so we start with the relevance, always start here. There are no questions, since we live in a challenging period for international law, interpretation of international law and application, because unfortunately inadequate application and negative expressions connected with lack of understanding. And the latest events in Russia have shown this. Here, of course, it's obvious that work on understanding of international law and such sources of it as treaties in the modern world and their significance of internal and external home affairs, domestic policy is highly relevant, because in my opinion the alternative is to international law is war and violence. So then the international law, in view of this, the international law should prevail. That is why I believe that an attempt of the author to understand what the international law is in the context of regulatory norms that can be applied in a particular sphere, such as arbitration, is very useful, and approach ideas, because it will increase awareness of our or the workers of our judicial system of this issue. And the first thing she said made me think, made me wonder, because she said, I want what is would be good for practical workers. And the problem is that our practitioners, they want to stay practitioners, and they don't want any theory. And because in American courts, cases are reviewed, so in my opinion, theory should not be divided from practice, cannot be divided from practice. So you should go beyond the limits of this such narrow and such narrow specialization. So here I support what was said by Ludmila Petrovna, without a broad understanding and further explanation to these bodies of how these should be interpreted is impossible. And in connection with this, I wonder, because maybe some points did not make it the task easier, but make it more complicated. It was clear before, and after you read the thesis, you become even more confused. And because of that, the situation gets worse, as a matter of fact. And because of that, the concept of international treaty as a legal act, we don't have much time for this discussion. So, I disagree with the opinion of the author. The reasons she's given are insufficient, because the author should have her own position. And here I agree with Ludmila Petrovna. also that our judges are not always sufficiently qualified, and so this causes certain problems. So it will be interesting to hear the author's opinion. And so the author says, I have this opinion and the court supports me. And so this, I think this is the end to any theoretical study. Obviously, this is not enough. But the main question here is, the main question I want to ask is why? How this interpretation of this concept, of this legal category, how it contributed to the solution of the practical challenge, how to improve understanding of what an international treaty is and how it can be applied at the lowest level. And moreover, by making this conclusion once, maybe not fully justified, and so you enter the realm of Russian legal acts, because that's what it says, what the thesis says. You said that yourself. The role of the treaty, so you think agreements are sources of Russian law. So then, what is the theory, recommendations to different systems? I suspect this could be a mistake, but here again, I agree with Lyudmila Petrovna that a scientific paper should be written very carefully, and you should be very careful with the terms, and even one in legal practice, even one preposition matters, even one. So here, I think, but well, okay, even if this is your opinion, you should give evidence. So what evidence do you give? So you think Sergei Yurovich developed a theory that has several levels, and so the mechanisms. So all treaties should have the same nature and should be interpreted. So, okay, I am impatient. I want to learn something new. So give us your evidence. So I wait for the author to explain mechanism, how this mechanism, how this new concept will be applied. That all treaties concluded by governments, we will apply them on the basis of the constitution and international legal norms, and there are no details. So you offer a new term, a new category, but you have not given any mechanism developed by you that would enable us to understand how this new vision will be implemented, how that will improve the situation, because we write something not for the purpose of writing, but we write something to solve a problem. So if we do this, we have to understand the problem, what are the challenges, but if we make the situation worse, maybe our approach is incorrect. And then the international legal reasons for application. So again, after reading monograph by Sergei Yurovich, and then I learned that these are the treaties. So I became completely confused. I don't understand how international treaties can be the basis for application of international law. This is pages 46, 47. And then you talk about the basic principles of domestic law, of their position. On one page, it's these are just principles of law, and I become even more confused because we have principles of law. So we have all kinds of different principles. So these are, and I would like to draw your attention to that. Though the approach to defining the theme and the approach are correct, is the need to create a theoretical and methodological basis for courts to understand what they are dealing with and what they do in a particular situation. In some cases, this work leads to creates extra confusion instead of clarifying these issues. These critical comments mostly relate to question 1, chapter 1, and further, I have a feeling that the author understands what she's talking about, but what never happened, in my opinion, the theoretical basis of the understanding of international treaties, its principles, its nature, its understanding as an element of the legal system of the Russian Federation, and how it could be applied in arbitration practice, because making the theoretical basis confusing. So these are my more main critical remarks, and I also agree with Lyudmila Petrovna that it's very important for me to hear your answers to my questions, which I have just asked. Here, maybe it would be sufficient for me. It will be to give your if you give your understanding why it is like this. How will you, as a practitioner, benefit? And then I will say, okay, I see, now I understand. Thank God, everything is clear. Why a legal normative act? Why given the same status? Why it's legal basis of international nature? And so please explain and then I will know how to vote in the end of this session. Thank you, Vyacheslav Vyacheslavovic, for your speech. I would like to give the floor to Sergei Yurovich Marochkin. Welcome, Sergei Yurovich. There's no need to remind you of the relevance of the theme. It was already mentioned by my colleagues. I'd like to mention one thing, as the degree applicant emphasizes this issue of implementation of an international law has been studied as general jurisdiction, constitutional court, and to lesser extent in the system of arbitration justice. And in regard of this research is highly relevant. The title is the word application catches immediately your attention. In my questions, my critical remarks, not in the so I've given them throughout my review. So maybe I shall go straight to this. So I paid attention to the term application in the title, based on the application is only one form of implementation of law. So maybe, so you made much narrower. But fortunately, the scope of your study, but I was wrong. With practice of arbitration courts, and in that sense, I got an answer to this question. But here, I think the term was application, it was wrong, and it could be in the it has also clearly formulated object and subject purpose of this study, which is obvious. I support the author's definition of novelty, and most provisions put for defense. I also found them not in the beginning, which is the normal standard practice, but then I thought maybe it's logical, because in this study, these provisions, they sum up the current state of affairs and serve as conclusions. So maybe this is logical. But anyways, in the beginning and the end, it doesn't matter so much. Some points seemed abstract to me and maybe not fully justified. For example, provision 6 is that among the key, the author mentioned introduction in Russia, international treaties in the Russian legal system, and understanding the highest authorities of norms of international treaties to determine their self-execution. So how is the introduction? How is this? So what does the author, how should they be introduced? How will this happen? What is the role of this introduction? The Constitution does not define the role of treaties in the legal system, and what will be the result of the norms. So what will be the significance? How will that happen? So I have not found answers to these questions. So hopefully the degree applicant will explain her opinion here. It's, to me, the provision 7 is also not clear. I don't understand the meaning of it. So I'd like to hear get some explanation from the applicant. Especially, I'd like to emphasize, maybe this is a formal, I'd like to emphasize the validity of the study, which is the opinions of the author, not practice, but this references proven with references to international and domestic legal acts and impressive practice. In other words, it also shows proves reliability of the thesis, and here it's, I would like to wish, maybe it's too late to ask the author or tell the author that she has not used the latest, the mostly works published some years ago. She's not using any foreign literature, though of course she's writing about Russia, but still since I try to watch what's happening abroad, there are many publications regarding Russian legal system and implementation of international obligations. So this segment of publications, opinions, as evaluations should be included in the work. The theoretical and practical significance to me is obvious because these, if not all, but the key the key provisions can be used for further theoretical research and first of all for discussion points mentioned by my colleagues, other members, to some of which I would like to points for discussion and for further development. As for the practical significance, I think the assessment given in the thesis of arbitration proceedings can assist the Supreme Court in making decisions on complex issues which we discussed today. This clarification of legal practice. And here I would like to wish the author to put all her conclusions and practical recommendations in a form that will be could be used to the Supreme Court or for the Supreme Court so that they could use these ideas and use them. As for the contents, some paragraphs to which I would like to draw your attention. Not all, so to me, the opinion of the author, paragraph 1, 2, about the legal force of international treaties within the legal system of the country. And Vyacheslav has already mentioned that the degree applicant for herself makes a conclusion that it is not necessary to build a hierarchy of treaties. Treaties should be considered treaties. All the international treaties indeed are treaties, and here the author is right. But the application in the process of application, it's necessary to know the status of the body that concluded the treaty. So, and here hierarchy, the question of hierarchy is inevitable with the legal and how the treaty corresponds to the legal and normative acts of the country. Not all the treaties could be supreme to all the legal acts in a country. And by the way, maybe all the rulings published by the Supreme Court regarding application of international treaties. And these rulings are used by the degree applicant, but she doesn't pay attention to the fact that in these rulings, treaties are ranked by who concluded, on what level a treaty was concluded. So this takes us to the issue of hierarchy. So here, I think maybe the degree applicant wanted to say something new, but at the same time, she did not provide sufficient arguments she could not come to a logical conclusion. Further, in chapter 2, characteristics of legal foundations, international legal foundations, was mentioned by other members of the, or has already been mentioned, so I will not repeat their comments. I'm sure the applicant has noted this question. The domestic foundations for application of international treaties, chapter 3, in my opinion, is most significant in terms of volume and significance. Is takes up 2/3 of the thesis, and by significance, by number of issues touched upon and analyzed, and here the degree applicant demonstrates her knowledge of the sphere about which she's writing. So to me, this is one of the most powerful, strongest parts of the thesis. And so I will try maybe to some extent to answer the questions asked here as the author is, uses she's not guided by theory, but she's guided by the practical needs. I think that this chapter proves indeed, from the outside, having analyzed the situation, and activities of courts to answer some difficult questions. Also, let me say the work would be better and stronger if the author brought together all the assessments. That could be a strong point of making this logical conclusion, would be a strong point of the entire work. One of the questions, why does the degree applicant focus is that treaties are legal, normative legal acts? So maybe, I don't know, I'm not trying to answer instead of the degree applicant. So maybe, if we look at this issue as a judge, so maybe to show that treaties are seen by judges as an agreement between the two states. So often they don't see treaties as obligatory norms. So maybe the author wanted to emphasize that these are obligatory. They should be followed, and treated the same way as the law. So that's the impression that I got. So I don't have any serious considerations. And in general, I think the work is logical, achieves tasks, solves the tasks the author has set herself. And I agree that a member of the Decision Council may change his opinion, and a member of the council and I believe that this is a member of a dissertation council should stick to his opinion, and I submitted my review a long time ago, and I still have the opinion which I included in the final part. I think the author deserves to be awarded the degree, and the work corresponds to the requirements. Thank you. To the applicant. Thank you, Sergey Yurievich. Here I referred to the procedure, the existing procedure for awarding academic degrees, which says that a member of the Dissertation Council may change his opinion. So this it should not be taken as a request to rebuke your opinion given earlier. Dear colleagues, our session has been going on for 2 hours, and before I give the floor to Professor Reinisch and make my own speech, I suggest we take a 10-minute break. Dear colleagues, do you have any objections? Let's ask Professor Reinisch, because he said, he asked how long the session will be, and he said, I told him the minimum duration is 2 hours, and I understand from years of experience, I told him that maybe it will take 2.5 hours, and then he said I will have enough time. So let us ask Professor Reinisch. Professor Reinisch, do you mind if we take a 10-minute break right now?
No, I'm perfectly fine with this. The only thing I indicated, and the reason for my question was that in a little bit less than an hour, I should join another Zoom meeting. But I presume we will be able to finish in time. So perfectly right.
Пять минут.
5 minutes. Let's break for
Я
5
поздравляю.
minutes.
Против 5
Do you
минут.
have any objections to break
Okay.
5 minutes? 5 minutes.
Благодарю.
We take
Тогда
a
через
5-minute break. Thank you.
13:05 мы встречаемся.
1:05. Let's come back.
Уважаемые коллеги, члены
Dear
Международного
colleagues,
совета,
members of the Dissertation Council, let us resume our session after a technical break, and let me give the floor to Professor Reinisch. Dr. Reinisch, the floor is yours.
Thank you very much. Also I would like to thank our candidate because we have a lot of questions now, and it will be a difficult task for her to answer them. Now, I am, of course, coming from a public international law background and would be particularly interested in two broad topics that have been touched upon in the dissertation. One is a conceptual one, referring to interpretation techniques, and the other probably a more detailed one, but again, because the question of treaty continuity, those treaties that were concluded by the Soviet Union, and I understand are still regularly applied by the Russian courts. There is some reference in the dissertation on treaty continuity as a technical and a practical solution. But for the public international lawyer, of course, the entire debate about identity, continuity, or succession is in our minds. And I would be interested in whether some of the court decisions that you have analyzed for your dissertation also treat this problem more explicitly, or whether it is possibly something that has not been touched upon by the courts. Now, that is mainly, of course, a question out of curiosity in regards to the actual court practice. The other one, dealing with interpretation, is, of course, one of the core problems that international lawyers face when it comes to treaties being applied by the domestic, by the national judiciary. And we can see that in many countries, courts have problems with following the interpretation technique prescribed in the Vienna Convention on the Law of Treaties. And I'm deliberately saying have problems because that may range from outright denial, saying we apply our domestic interpretation canons, to paying lip service to the Vienna Convention, to actually engaging, and I think that is the main problem, engaging with Article 31 of the Vienna Convention and applying the interpretation rule there, even though maybe domestic interpretation canons would have different emphasis, would focus on different aspects. And again, I would like you to elaborate a bit on this to explain to what extent in those cases where the commercial courts in the Russian Federation apply treaties, do so in accordance with public international law interpretation approaches, or rather stay with the domestic paradigms of interpretation. Those would be the two aspects I would invite you to clarify in your answers. I should add that I enjoyed reading your dissertation. It is a challenging task, and I think that it was well performed, although, of course, I'm not versed, as I said, in the Russian constitutional debate and all the other intricacies of domestic law, which my colleagues can assess much better than I do. Thank you.
Thank you, Dr. Vanish. And only now it's my turn. And since we have certain time limit, I will have to be brief. My review to the thesis is negative, and in my written review, I've given reasons for this conclusion. And so I will focus on maybe on the most significant, in my opinion, points, and will omit all the details. I think that when we read the theme, when we see the theme is application of practice of arbitration courts, this study suggests some solid empirical foundation. So first, we notice that the empirical foundation in this study is absent from the introduction. And when explaining the methodology, the author says that the choice of legal acts was done in a very general methods, but does not explain, doesn't give any characteristics of the empirical base, and we cannot but notice the amount to describe problems arbitration courts over 30 cases. So 30 cases, the number of cases is certainly insufficient, which for the author is the first theoretical and practical issues of application in arbitration practices, which span the entire period since arbitration code became effective in 2002. And of course, to see in the thesis like that, so you expect to, is it possible, you see in arbitration practices any changes or tendencies? So what types of theoretical, practical challenges there are? So maybe it's impossible to answer these questions having analyzed only 30 cases. It's a shame the author is not asking these questions. And so, in my opinion, the study is the subject is absent. And when the author of the thesis says that it proves that this conclusion is not well grounded, and there are no references to applicable cases, maybe only one or two cases are used as examples, and it seems that the theme seems to be very wide, and it seems the author should have clarified type of treaties to get a better vision of the practice, to register certain types of problems, so this practice could be a reliable empirical foundation for the study. And as has already been mentioned many times, the legal normative act in my review, I even admit that let there be 100 colors, 100 shades. But I think this definition is leads to a contradiction of the in the reasoning of the author. We get the impression that if we call the international treaty a legal act, it's not clear why one should be taken and something else. The international treaty is not some pseudo source of law, and in our legal system it should be called a legal act. So here I agree with Vyacheslav Vislaush and Ludmila Petrovna that the power of an international agreement, but these contradictions, which I describe in my review, I will not list all of them because I think this this definition of an international treaty is, I think it really misses the target. And the second point is the controversial opinion of Olga Anatolyevna about on the relation of international law and the Constitution. And here I asked in my review on which theory her opinion is based. And I think it's very the explanation is very controversial. And on the one hand, the author says that legal force should not be related to the legal force of the national law. So there's no differentiation. There should be no differentiation between domestic and international treaties and laws. Okay, but by putting the international treaties after the Constitution, this already is a result of comparing the legal power, the legal force, and it's impossible to, which cannot be avoided. So, of course, such novels in legal terminology is well, actually hard to understand, and in the form of Russian legal interpretation. And so then I will proceed to the provisions. Provisions good for defense. As for the first provision, where the author talking about the high role of international treaties. This conclusion on the analysis, based on the analysis of practice of the Constitution, it seems to me that it's hard to see any novelty in this. The second thesis
where the author simply mentions lack of uniformity, is the provision 3. Once again, the author repeats that the practice of application of international treaties is contradictory and inconsistent, and then gives some reasons for this situation, references to insufficiency and inconsistency because the judges are busy. As I understand that such references are too general and can be used to describe the state of affairs in any sphere. There's no definition of a treaty or a legal act. In the article of Vitaly Simonovich, academic advisor, this approach has been described. So I don't think that this provision can be put out for defense, which has scientific novelty. In the 5th provision, the author says that it is an international treaty. Their role should be be described in the Constitution. So then, how does that relate to the earlier statement that international provisions are excluded from legal acts regulated but subject to the Constitution? As for the 6th provision, to which Sergei Yurevich also paid attention, and the 7th provision as well, so I will not mention this. So the 8th provision characterizes interpretation of international treaties could promote a practice of better application of international treaties in arbitration courts. But this thesis would deserve attention, except for one circumstance. This gives references to only 4 decisions of international judicial institutions. So the paragraph dedicated to this only mentions 1 resolution of European Court of Human Rights and EU Court. So the validity of this provision causes doubts. So the 9th provision describes a model of activity of arbitration courts in Russia for administration of justice in the event of assent. It sounds very promising, but in the text of the thesis, the correspondence such correspondence cannot be traced. So these provisions they have no scientific novelty, or whether they do not correspond to the subject of the study, and they contradict each other and are not sufficiently grounded. I beg your pardon for to make it so brief. Beg your pardon to make it so brief. But my review has been published at the applicant's webpage, and I think that, in my opinion,
there's no does not deserve to be awarded the degree of Candidate of Legal Sciences, in my opinion. So the author should not be awarded the degree. Thank you. Dear colleagues, I would like to give the floor to Olga Anatolyevna. I understand that you've got a whole bunch of questions to answer. Please remember the time limit, and remember that Professor Reinisch has to leave us. soon. So but we want him to take part in the voting. Olga Anatolyevna, thank you for giving the floor to me. I will try to answer all the questions asked in written reviews and asked now. Dear Chairman, dear members of the Dissertation Council, first of all, I would like to thank you for agreeing to take part in the work of the Council, for reading and for your reviews, for reading my thesis. And I would also like to thank Professor Olga and judge of the Kante-Mansi Arbitration Court, Vera Andreevna Becker, for their positive feedbacks. First, I would like to give brief comments to different texts of the thesis, as well as not very accurate use of terminology. There are translation issues noted by Professor Reinisch, and in some cases the translation was complicated by the wording of complex sentences. The terms arbitration and commercial are assumed to be identical in the English version of the thesis. At the same time, it would be more accurate to use the term commercial, since in this case the possible confusion between international commercial arbitration and Russian national arbitration costs should be excluded. I have to state there are some cases use of legal terminology is incorrect. Distinguished members of the Council, your feedback contains a large number of questions, comments, and suggestions. They are all very important and deserve attention and discussion. But I agree with many of them, and I thank you for your comments and for your work, and I will certainly take them into account in my future scientific and practical activity. Yet, I'd like to comment on some of them. First of all, on theoretical and general, Elena Vladimirovna, among other comments, should draw attention to the non-standard design of the structure. So we discussed with my academic advisor. He convinced me they would be more logical in the introduction to reflect relevance and goals and objectives, and conclusion to summarize the results of the study. I agree with this. Dear colleagues, considering the limited time that we have, I suggest that you answer more critical remarks of Vyacheslav Vyacheslamovich, Lyudmila Petrovna. So that is about the concept of international treaty. So my secondary comments regarding the structure of the work, these are not points for discussion. The structure of the work is as it is. It cannot be corrected. Elena Vladimirovna, about the empirical basis. So please proceed. Okay. Yes, the empirical basis is absent. So this impression is when it's studied material, not having identified the empirical component. In fact, the empirical basis is judicial practice and cases, acts somehow connected with international law. At the same time, working as a long time in arbitration courts, so knowing the peculiarities, and I took into account not only formal opinions of arbitration courts of the different resolutions, but also the reasons, the foundations for which such decisions were made, because they're talking about a considerable number of courts with which we reviewed where I worked. Moreover, preparing for court sittings and writing drafts of court acts, it's often necessary to analyze the judicial practice of other regions, and did this on daily basis. So the empirical basis of the study is not only reflected in the list of a little over 30 arbitration cases, but also in dozens of other judicial acts. I'd like to emphasize as there are 44, including and 2 acts of Supreme Court, which was issued by the panel on economic disputes. Moreover, citing of judicial acts and reduction of their names in the text was intentionally reduced to a minimum, as it essentially increases the volume of the work. to which there are clear requirements, and references were given only in cases that require detailed analysis. And further, as for Anatolyevna's comment that the author failed to choose the right angle of consideration, is the subject of my studies, social relations emerging in the process of administration of justice by arbitration of courts, situations where there is a question need to apply the rules of international treaties. So by choosing to narrow down the subject matter, by choosing the type of treaties, do not seem appropriate. First, the amount of empirical case will be substantially limited, and secondly, referring to the same contract, legal position of the courts turns out to be identical regardless of specific circumstances of the case. Here, the role is played by the desire of uniformity of court practice. Further, let me skip some comments, which you asked me to skip. What else I would like to add? Sergei Yurievich said would be more appropriate for the title of the work and perhaps to be more fully and accurately reflected terms of all forms of implementation of international treaty norms. As for the work as a whole, the main idea of the scientific knowledge was, after all, professional activity of judges of arbitration courts in administration of justice, in which they, of course, apply the rules of international law. So that is, translate specific provisions of into real behavior of subjects. However, in terms of discussion and further research, we believe it would be interesting to think about answering the following question. If a judge acts in a procedural part in accordance with an international treaty, does he execute or apply it? Of course, it depends on the wording of the law itself. But this is a question of theory as it applies to court proceedings is fully studied. Now, so let's proceed to the main comments on chapter 1. Anatolyevna noted that the thesis, the international treaty is a regulatory legal act, was set out in 2015 by Vitaly Tymoshenko and therefore cannot be defended as in addition, Anatolyevna raises question, why turn international treaties into normative acts in the national legal system? Kiseleva noted that the thesis, such a characteristic and normative instrument, the adoption by the authorized body of the state is not the main one, but only supplements and clarifies the quality of such an instrument created within the national legal system. Examples of administrative, legal, and tax codes are rather a shortcoming of the Russian legislation and rather an confirmation of the author's position. But Nina Petrovna thinks the qualification of international treaties should not take the form of mechanical transfer to the ground of international law patterns that existed in domestic law. The essence of the international treaty is its conciliation nature, which excludes its transformation to an act of domestic legal system. At the same time, according to Nina Petrovna, the qualification of an international treaty as an international legal act can create uncertainty about the true legal properties of the treaty. We also emphasized by Vyacheslav Vyacheslamovich in his review. And according to Lyudmila Petrovna, the thesis does not contain a study of the imminent specificity of the regulatory framework of the treaty. I agree that in my work, I hold the specific position of my academic advisor, Vitaly Semyonovich. However, I believe that continuation of further development of the ideas of academic advisor is justified and logical interaction between the applicant and the academic advisor within the framework of the candidate's thesis. But what is important, the definition of an international treaty as a normative legal instrument that I proposed in the framework of my thesis differs from that proposed by Vitaly Semyonovich in his works, which I think complements the arguments in favor for this understanding. I want to pay attention to the following. Feedback, reviews, respected opponents in one or another form contain non-recognition or doubt about characteristics of international treaty as a normative instrument. Indeed, this understanding of the international treaty is still controversial, as, however, I gave my opinion in addition, I may say that the foundations in paragraph 1.2 is, first of all, the active provisions of Russian legislation resolutions of the Constitutional Court, opinions of the author on unity of law and characteristic of sources of law, purpose in science, and analysis of legal definitions of international treaties, which we have studied. Thus, we came to the conclusion, controversial conclusion, that I would like, in this case, to use some support from Sergei Yurevich, who said that these conclusions, with this conclusion, we wanted to show this foreign nature for arbitration courts of international treaty when it is explained on the basis of its reconciliatory nature, but we do not this nature. We just suggest another. We are suggesting another for addition to assess this treaty. At that, please pay attention that in the first paragraph of our work, we identified characteristics of international treaty as a legal act which do not contradict that this conclusion has can be valid. First of all, it contains norms of law, norms that are obligatory for then it is authorized acts and acts of has legal effect and has legal effect in the national legal systems if sanctioned by such system. Is applied in strict procedural order for which whole set procedural rules exists, has a written form, corresponds to international rules of international law of drawing up documents. At that, I'd like to say that such conclusion indeed gives the basic understanding for that this act is applicable, that this act is applicable in the given legal system, can lead to the conclusion which place an international treaty occupies in this system of sources of applicable law in the framework of legal framework of Russian Federation. Moreover, we may say that on the basis of this conclusion, other conclusions that we make in our thesis, that the order of application of international treaties, and moreover, I'd like to emphasize that the exception of reconciliatory nature becomes secondary in of an international treaty, allows us to exclude understanding of the international treaty, the very concept of a treaty in private legal relations from the terminology used in these relations. In our opinion, these conclusions could promote development and not complicate development of judicial practice, court practices. Let me continue. According to Sergeyevich and Vyacheslav, paragraphs 1, 2, and 1, 3 we put in the conclusions in the hierarchy and do not solve the problem, but is confusing. It seems to me that the above paragraphs analyzed and disclosed various positions of scholars, norms of domestic law and international treaties, and express the author's position on the legal force and place of treaties in the legal system. Perhaps we should have formulated our position more clearly. In addition, Elena Vladimir indicates that there are separate internal contradictions in the conclusion set in paragraph 1.2. In my opinion, the sense of contradiction results not from our lack of clarity. In my thesis, I assert that international treaties, international legal acts acquire this not in the national law, but in the international law, which follows from the chosen wording and subsequent justification of views on the legal force of treaties. In this case, based on the theory of law enforcement complexes, these international regulations are acts applicable in our legal system and not outside the Russian legal system. From this general message, we conclude that the international treaty is required in national legal system. In the Russian legal system, legal properties of an international treaty are manifest in the process of concluding an international treaty and law enforcement practices. It's important to emphasize that according to the Vienna Convention on the Law of Treaties, all treaties have equal legal force regardless of the organ that concluded the treaty on behalf of the state. At that, also, I'd like to draw your attention to the following. Paragraph 5 contains role of not in the system of Russian law, but in the system of sources of law to be used by the Russian arbitration courts. And let me emphasize that law in this case is understood as a more general category, as a system-wide category comprising both national and international law. Such a role has been determined exactly on the basis of the provisions of the Constitution of the Russian Federation and the Arbitration Procedure Code of the Russian Federation, and provisions in my thesis. Comments on Chapter 2 of the thesis. Elena Vladimirovna, paragraph suggests the following comments. The grounds of application are traditionally divided into normative and factual, not legal and factual, and the advantages of the and the is not and not so in this case we made an attempt to present in a consistent and understandable way the scope of legal foundations that should be laid down in the application of the norm in the national treaty. The term legal, used as a counterbalance to actual and analogous normative, was chosen to reflect the more regulatory nature of those sources that contain such grounds, in our opinion. Sergei Yurovich made separate contents on subsection of paragraph 2.2. In his opinion, different phenomena of legal reality are mixed up. Vyacheslav does not agree that the legal grounds of the international nature of the norms of the international treaties include international treaties, the basic principles of international law, international custom, and certain decisions of international law. Lyudmila Petrovna also disagrees that the inclusion of the treaties themselves as grounds for the application of international treaties. Leonardina thinks that paragraph 2.2 does not disclose the declared subject, but proposes to characterize the sources of international law. In this case, we are forced to admit that there are several incorrect formulations that have distorted the general perception. However, in the meaningful way in this paragraph, we have attempted to set out the legal elements that we have laid down as the basis of the international legal grounds for the application of the international treaty norms. The European Court of Human Rights acts were only the most vivid example, as it tend to take into account the positions of European Court. In some cases, can even find references to the rulings of the CIS Court. With regard to treaties as grounds for the application, in our view, this is possible in some cases. The same Vienna Convention of 1869 contains rules that constitute the basis for and govern its application. As Mr. Ryan asked, can pacta sum servanda be qualified as jus cogens norm? The Russian doctrine of international law classifies all principles of the international law, including such a fundamental principle as pacta sum servanda, as imperative jus cogens norms, which state must not derogate. According to Dr. Reinisch, the distinction between customary international law and customary principles arising in trade law is not sufficiently drawn. I agree that a more thorough analysis of norms is required. After all, both may not be applicable in the arbitration processes, but also become the basis for such application, since the arbitration processes is closest to the trade law. However, the limited scope of the thesis wouldn't allow us to dwell on this issue in more detail. Sergei Yuryevich and Elena Vladimirovna note that the role of legal culture in arbitration proceedings has not been demonstrated. It's true that legal culture has not been a subject of special consideration, but the need to develop this area through training of judges, introduction of relevant explanations, and so on has been repeatedly mentioned in my work. Vyacheslav is asking, what is the difference between the basic principles of domestic law and just principles of law? And Why were these principles included? Through my analysis, we identified principles that we believe are most important to the national legal system, which are the fundamental principles or directly related to arbitration proceedings. As for comments on Chapter 3, I guess Mr. Reinisch is asking, what extent can the scope of authority be properly considered as procedural laws? We refer to the procedural rules as the very need to define the powers. This activity is a procedural action that the court must perform before starting consideration of a case. Of course, the scope of authority itself is determined by the legal norms of the state to which a particular subject belongs. Then the Dimona thinks that paragraph 3.1 has title problems, but in the paragraph itself there are no problems, and the content intersects with the next paragraph. Perhaps this perception of the paragraph is due to the fact that I was not able to clearly define the material in question as problematic, although I beg your pardon, Olga Anatolyevna. Lyudmila Petrovna is not, we cannot see Lyudmila Petrovna, so unfortunately we have to take a technical break. Lyudmila Petrovna, please come back. I'm here. No, Lyudmila Petrovna is with us. So thank you for getting back. Please continue. Please remember that I'm doing my best. Thank you very much. As the number 23 analysis is as superfluous. I do not consider it to be a complex. This is an example from judicial practice, to which the author is not but a single judge, but a panel of judges. Then Verina also had questions regarding official interpretation of international treaties. Thesis points out that each arbitration court applying rules of international treaty interprets them to some extent. However, only the application and explanation of such a rule by the highest court is an act of official international legal interpretation on behalf of the Russian Federation. Dr. Reinisch and Lyudmila believe that paragraph 3 would be useful to provide more examples of practice through international judicial decisions. We have this intention, but the volume of international practice is so large that it's impossible to analyze it on 3 or 4 pages, and there's no place in the thesis. We plan to use the European Court on Human Rights ruling in Alenika versus Russia case, in which the European Court applied to the institution of state judicial immunity, and which I have already mentioned, taken. Let me. I cannot deny positive influence. Arbitration courts, all this, and conclusions on possibility of implementation, even if there's no in absence. August, Dr. Reinisch also seems to broadly stated the acts of international organizations are not treated as treaties. And many organizations state in their statutes that their resolutions are binding and simply act as interpretation would be too limited. I totally agree with this point of view. The work addresses the issue of application of instruments of international law that have no legal effect but are clearly insufficient. This requires more, but position of act of air carriers, which the conclusion is mandatory, and this act has been analyzed by the arbitration court, which also mentioned in this. So this issue requires more extensive research, in my opinion. Lyudmila Petrovna thinks that the author, without critical, supports the initiative to introduce an institution of procedural request of any arbitration court to the Supreme Judicial Authority. Why I support this initiative? There's a strict framework for existing the procedural power of a judge, at that each judge is trying to has time limits. So despite this request is made, the procedural time limit is suspended. In fact, the reporting system is designed to reflect all these extensions of time limits, and in order to so judges is not do not want to use this right. As for provisions put for Ludmila Petrovna Vladimirovna had similar comments regarding the third conclusion. Conclusion 1, evasive, blurred conclusion. My first conclusion is want to show and the state of the system of arbitration proceedings at the time when at the moment, after many years of unwillingness, uncertainty, caution, arbitration courts have gradually begun to apply the rules of international treaties, and this is becoming a more common practice. Second conclusion, according to components, has no theoretical component. I agree, but I wasn't aiming for that. This conclusion is of practical nature. But this conclusion has sought to logically continue the provisions of the first conclusion and to show that the process of adaptation of the Russian arbitration system to the new conditions of its functioning with the active use of international rules is not yet complete, and it's necessary to further achieve uniformity in the general issues of understanding application of the international treaties by the Russian arbitration courts. And here, the need remains not only for theoretical developments, but also for the introduction of various direct tools to ensure this uniformity. The third conclusion is a general list of imperfections and defects of the legal systems as such, according to opponents. In my opinion, if the result of the scientific analysis is revealed and systematized as a result of this, it creates a good opportunity to establish the reasons for this and to search for ways to improve the arbitration system. I've introduced these conclusions to the judges, and they were very interested in these conclusions, and they liked them. Typical to arbitration courts. And at the same time, if you look at the practice of applying legal norms, they don't have such problems, even in the case of contradictory nature of regulations and clarifications by higher courts, even though they have supreme legal interest. Anatolyevna asked the question about the fifth provision, that international treaties in the hierarchy of sources of the Russian law should take after the constitution, and how this relates to the statement made on page 61 of the thesis that the systematic interpretation of the constitution shows that the international treaties are excluded from the norm. I'm very grateful to Vladimir for this question. It's a very complex issue, which is still under active discussion in the light of the upcoming vote for constitution amendments. In process of working on my thesis, I formed a firm belief that in question of correlation between the constitution and the international treaties, it's not a question of formal subordination of these legal acts, but of priority of their norms in a specific law enforcement situation. Since I'm engaged in international law research, a well-known provision in Article 27 of the Vienna Convention that states this does not refer to domestic law to explain not following provisions of international treaty. The same applies to the provisions of the Constitution. At the same time, in my work, I note inconsistent with the provisions expressed that international treaties must comply with the Constitution of the Russian Federation. It is impossible to imagine a normative act of, in my opinion, of international law cannot correspond to the n number of provisions of the Constitution. And therefore, it's not a question of consistency of the treaty norms with the Constitution. Several decisions of European Court caused great public resonance, were related not to Russia's refusal to comply with European Convention, but its refusal to comply with European Court of Human Rights decisions in its interpretation of the Convention's norm that contradict the Russian Constitution. Olga Anatolyevna, please focus on the main provisions that you still have, because we are going beyond the limits. Please focus on the most important points in your opinion. Also, I'd like to emphasize that Many comments mean that the work is practical, is of a practical nature, and there are no theoretical, has no theoretical value. In my opinion, we have analyzed many scientific works and opinions of different authors, and the position of the author have been tested on the platform of Russian Association of International Law, discussed. So we discussed, we came to conclusions, certain conclusions, and in this regard, the work has both scientific and practical value, and may be called a theoretical. And on the basis of the theoretical conclusions that we have tried to justify, we explored judicial practice, court practices, which we described in the third chapter. Regarding other comments, which I would like to answer, Dr. Reinisch says that we should discuss public international law continuity. This concept has been developed in the Russian literature. It can be indeed play an important role for judges from the point of drawing conclusions about validity and relevance to legal relations of international treaties concluded in the previous periods of by our state. But in practice, in legal practices, so we have that this is an interesting subject which can be further explored. Regarding another comment, question by which state authorities clarify the content of international treaties in order to ascertain their self-executing nature. In our opinion, this authority belongs today to the Supreme Court and the Constitutional Court. However, I don't recall a single clarification or self-executing. We believe such a statement should be made at the stage of transfer of the treaty for formal publication, which means there should be an organ participate in the signature of the treaty on behalf of the state. I did my best to answer all questions asked, but unfortunately, because of limited time, I cannot expand on some questions, and I think my speech is over. Thank you, Olga Anatolyevna. Dear members of the Dissertation Council, I have to ask, are you satisfied with the answers, or do you have any, maybe I should ask if you have any unanswered questions which Olga Anatolyevna should have clarified? Ludmila Petrovna, do you have any questions which Olga Anatolyevna should explain, in your opinion? If we are talking that according to reviews, there are answers of the author, of course, the scientific discussion should include some reaction after the reviews have been presented to questions and comments made by Matt. And so that means the conclusion, the obvious conclusion here is that the final word should belong to the scientific discussion that should take place. And discussion means sharing opinions. As for me personally, in this case, I cannot agree with the reasons given by the author as answers to my comments and remarks. I could not see anything new except in regard to my to this circumstance, and the answers given by the author resulted in more questions. So honestly, I don't see a solution to this situation. So it's not getting clearer, it's getting more and more obscure. Thank you, Lyudmila Petrovna. Vyacheslav Vyacheslamovich, do you have any questions which the author has not answered? No, I don't have questions. I have one small comment. I understand is global. Of course, it's impossible to resolve global issues, and I think the discussion will not lead to any results. And the author tried on the basis of her scientific development and knowledge. In my opinion, it was interesting with due energy. I only asked one question. I asked the author to explain how, in her opinion, these two theoretical structures are connected with practice and why she did this. And I got the answer. The opinion of the author is clear. I wouldn't say I agree, but at least I got the answer to this question, so I'm satisfied with the answer. Thank you. Sergey Yurievich, do you have any unanswered questions that Olga Anatolyevna still needs to clarify? In my opinion, the author covered all the questions, so I don't have any further questions. Thank you, Sergey Yurievich. Professor Reinisch, are you satisfied with the answers to your questions?
I have no follow-up questions. No, I think the candidate very thoroughly addressed all the issues.
Thank you. And I would like to ask Ekaterina Vyacheslaevna if we received any questions by email. No, we have not received any questions. Thank you. Then, Vitaly Simonovich, let me give the floor to you to characterize the work of Olga Anatolyevna, but please remember the time limit, not more than 5 minutes we have. Thank you. Can you hear me? Yes, we can hear you. Of course, I prepared a more detailed answer, but because of the current situation, I have to be brief. So let me say the following. Today, for me and for degree applicant, the day is very important. There was no other candidate with whom I've been working for 11 years, but as all academic advisors, we always have to answer this question: which topic should be given to the author? I proposed this topic because I thought it is relevant, not well or very poorly studied, and third, that the applicant works in this sphere which she will study. To me, that was important, and the applicant was very responsible for various reasons. It took her longer, and the structure of her work has changed. Concepts have changed, but I set herself this task, and I think she managed to. The work should be of theoretical and practical nature. I heard the objections regarding the scientific component, but in the course of my work, I had to deal with many descriptions, and in order to, and in my opinion, I succeeded. to do this. It's important that what is starting a discussion. Many issues that we have discussed, questions asked by the distinguished opponents. None of the questions asked by opponents, so there is no there are no universal opinion. There's no single opinion in the scientific community. So to require that the author of the candidate's thesis to answer these questions is too much, would be too much. And there is no uniformity of approach of domestic law and relation, ratio of constitution, international treaties, and the role of international treaties in the legal system are being discussed. So this is a source of law, but so there are many theses called international treaty as a source of international of the constitutional law. So today the theoreticians and thesis authors believe that treaty is a source of law. So this is a point for discussion. What is the position? What is the role? And I wrote an article on this international treaty, and then I recalled my article. The editor-in-chief approved, so I recalled my article, but when I insisted that the author should focus on the treaty as a legal normative act. Why? Because I was surprised by the position taken by our scientists, the Moscow scientists, first of all, and the federal authorities. The Constitutional Court sent a request if an international treaty is a legal act. It's exactly, this was the wording of the question. And it is part 3, Article 15 of the Constitution, which says the Russian Federation legal acts which have not been published cannot be applied. And Moscow professors answered that treaties are not legal acts. The federal norms is denied this, but when the Constitutional Court said that international treaties should be published within 3 weeks, and international treaty that have not been published in Russia cannot be applied. International treaty was classified as Vitaly Semyonovich, I'm coming to the end. Scientific and practice, so whether should be defined or should not be defined. So if should not be applied, and many others. So I believe that the degree applicant meets the requirements, submitted an independent study, completed piece of writing, the articles that she published, and I believe that after 5, 10, 15 years, international treaty will be recognized as a legal act, shall be recognized as a legal act. And I believe that Olga Anatolyevna deserves to be awarded the degree of Candidate of Legal Sciences. Thank you, Vitaly Semyonovich. Dear colleagues, since we are working in remote access mode, I have to ask, according to the procedure, I have to ask if you have any, the dear dissertation council members, Olga Anatolyevna, Vitaly Semyonovich, do you have any unanswered questions regarding the procedure? please say no if you don't have any questions regarding the procedure of today's session. No, we don't. No questions. Thank you. Dear colleagues, thank you. And now we have two options. First option, we stop video broadcasting to discuss the results of defense before each of us votes for or against awarding the degree to Olga Anatolyevna. We may break for a discussion, closed discussion, or if colleagues think that such discussion is not necessary and we are ready, each of us is ready to vote, we can proceed straight to voting. Dear colleagues, what is your opinion? Ludmila Petrovna. I think we don't need such a discussion, but of course, if my colleagues wanted, so we're talking about not about making an agreement, but it's about a discussion, because of course, thank you, Ludmila Petrovna. Vyacheslav Vyacheslamovich, your opinion? Do we need to take a break to discuss, or we are ready? Each of us has an opinion, and we are ready to vote. I am ready to vote. Thank you. Sergey Yurievich, I am ready to vote. And Professor Reinisch, are you ready to vote right now?
Yes, I would be fine with that.
Good. Thank you. Okay. Then let us proceed to voting. I put the question of awarding to Kiseleva Olga Anatolyevna the degree of Candidate of Legal Sciences, Academic Specialization 120010, International Law, European Law, to the open individual vote. Let me remind you that a decision of the Dissertation Council shall be considered positive if more than a half, but not less than 3 members of the Council who took part in the session voted for it. And let me remind you that opinions should be given in public. So I will ask, dear Ludmila Petrovna, what is your opinion? So please answer the question. So first question is a question to award or not to award the degree to Olga Anatolyevna. I think I abstain. Okay, thank you, Ludmila Petrovna. Vyacheslav Vyacheslamovich, what is your opinion? Your opinion? I vote for awarding the degree. Thank you, Vyacheslav Vyacheslamovich. Sergey Yurievich, what is your opinion? I am for awarding the degree. And Professor Reinisch, what is your opinion? What is your opinion?
I'm in favor of awarding the degree.
Thank you. And I still have the same opinion. I vote against. Thus, 3 members voted for awarding the degree to Olga Anatolyevna Kiseleva, the degree of Candidate of Legal Sciences. And dear colleagues, dear guests, I announce that the decision to award to Kiseleva Olga Anatolyevna the degree of Candidate of Legal Sciences, Academic Specialization 120010, International Law, European Law, has been made, and by the majority of votes, 3 votes. 3 persons voted. Olga Anatolyevna, let me, on the behalf of the Dissertation Council members and on my behalf, to congratulate you on being awarding the degree of Candidate of Legal Sciences, and your final remarks. First, I have to ask once again, since our meeting, do members of the Dissertation Council, do you still have questions or comments regarding the procedure of today's defense? Olga Anatolyevna, Vitaly Simonovich, Professor Reinisch, do you have any questions regarding the procedure? Only the procedure? Thank you, colleagues. Then I would like to give the floor to Olga Anatolyevna, the chairman, dear members of the Session Council. I am very grateful for today's session. I am very happy that it happened. I am very grateful to my academic advisor, my guide in the realm of science, and your critical comments and remarks. I will certainly take them into consideration. I really try to answer each and every comment, and I shall certainly take them into account in my future work, and I will try to live up to the expectations of this Dissertation Council. Thank you very much. Thank you, Olga Anatolyevna. Thank you, dear colleagues. Thus, I declare the session of our Dissertation Council closed, and please stop I ask the technical department to stop online broadcasting of our session. Thank you.